welcome to the 10th edition of the Vis East Commercial Arbitration, Moot. We are delighted to have you here. 93 teams, 250 arbitrators, about 1,000 people in total here. This 6 months of work on behalf of all of these teams is culminating this morning in the finals round between the two teams who have worked very hard to become the outstanding teams among the 93 of you that are here present. And we're going to see a terrific argument, I am convinced of that. We have a very esteemed panel this morning. Most of them are already known to you, but I'm going to introduce them for the record. We have Hugh Dundas, who is a chartered arbitrator and mediator with 30 years in the oil and gas industry. And Hugh is a former president of the Chartered Institute of Arbitrators, 2007. And he is also one of the most stalwart supporters of the Vis and the Vis East, having had many hours working on the various problems over the years, and also being a terrific moral support to both organizers, both Eric Bergston in Vienna and to me. He's based in Scotland and London, and also has substantial interest in Asia. Tao Jingzhao is the managing partner of Deckert and is responsible for the development of their Asian business there. And he is also a French avocat. And Tao is also a member of the ICC Court of Arbitration. He's just been renewed for another term there, and he is based in Beijing. And our third panelist is Ms. Edma Sussman, who is an independent arbitrator and mediator after being of counsel to a well-known New York law firm for many years. She's a distinguished ADR practitioner in residence at Fordham Law School. She's vice chair of the New York International Arbitration Committee, New York Bar International Arbitration Committee, and is a board member of the AAA or ICDR. And Edna is based in New York. So I think we're going to have a terrific panel with lots of good questions. And representing the claimant this morning, we have the University of Canberra, and James Stavridis and Simon Hall will speak for the claimant. For the respondent, we have the Westfälische Universität Munster, and we have Loritz Schommers and Annabella Matisiak-Kiala. So with that, I will hand the microphone to the president and ask the panel to begin.
Good morning, colleagues, council, and distinguished guests and others in the room. It's a pleasure to be here and a great honor and a privilege to be here on the 10th of the Vis East Moots. And we the panel, are very grateful to Louise for allowing us to be here. Before we commence the argument proper, I'd just like to cover a couple of items of a kind of a housekeeping nature, so that both parties know where we're going to go in the next hour and a half. First, as both parties are well aware, I have seen each of you during the week in different capacities, and it seems to me that as I've seen each of you, neither of you is disadvantaged, and I hope you'll raise no objection on that. Second, of the issues facing us during this arbitration that we're about to commence, the tribunal is significantly more interested in Article 96 and choice of law issues on the one hand, and avoidance, breach of contract, damages issues on the others, and we'd like to park anything to do with witness statements and anything to do with whether or not the contract was amended. We'd like to park those, focus on the other two issues first, and we'll come back to the witness statement and the amendment issue or later if there is time. And if there isn't, that's fine by us. That's the way we'll see it. So we have approximately 80 to 90 minutes, split 4 ways. I don't need a calculator for that, and I'm sure you don't. As to how you want to divide the time, I'll ask you in a moment. I'm going to offer you, and unless you want to reject it, but we will go for, or the tribunal is suggesting we go for rebuttal and sur-rebuttal, and we're going to be reasonably flexible in that regard. In some moots and in some courts, there is a rigid cut-off as to time, not today, but if I think you're starting to run a little short on time, and I do have a clock and I will be counting it, I may interrupt, maybe to give you a 2-minute warning, or given the logistics of what happens after this argument is closed, it may be that I'll have to cut you off, but I hope not, but be ready for that. And certainly in the general rounds of the moot, there are certain limitations as to the nature and content of questions that panels might ask. This is the final. I don't think we feel particularly constrained in respect of what the questions might be. So stopping there, is there anything that I've said that to which Claimant takes exception? And Respondent? Thank you. In that case, I declare these proceedings open, and one point that needs to be cleared, it is reasonably common, certainly in English London arbitration, that arbitrators or parties, party solicitors, can bring pupils to attend the arbitration to gain the experience of attendance. As you may have noticed, there are a few pupils in the room witnessing this arbitration. May I take it that Claimant finds that acceptable? Respondent? And I should clarify that, of course, the pupils will play no part in these proceedings at all and will not participate in deliberations. Thank you. Another point of housekeeping is that, as you may be aware, I am chairman of the advisory board of the Chinese European Arbitration Centre, but as you can find out, if you wish, I have no role, we have no role whatsoever in the day-to-day management of SIAC, and therefore case management and similar things are on the other side of a pretty thick Chinese wall. So does Claimant wish to take exception to my position in that regard? No. And Respondent? Fine, thank you. In your submissions, there's a lot, I'm no doubt you're going to tell us, but in respect of each of the two main issues that I've asked you to focus on, within that there are two sub-issues in each case that you will, I assume, be bringing into your submissions anyway, but the tribunal has a particularly strong interest. In respect of the choice of law Article 96 issue, we're particularly interested in the interpretation of the closest connection test. And we're also interested in the interpretation of Article 20 of the contract and Articles 12 and 96 of CISG. Do we, as an arbitral tribunal, enjoy any flexibility that might be unavailable to a state court? And in respect of the main contractual issues, where we are particularly interested in, and I'm sure you're going to address, the issue of foreseeability, and we're also interested in the applicability or not of Article 82 CISG. So any questions from Claimant on these issues that we would welcome your assistance on? No? Respondent? Fine. In that case, in which order do Council wish to take these proceedings?
It has been agreed by the parties that Respondent should start on procedural issues, and then it will come to Claimant, and then proceed to Claimant again for substantive issues, and then on to Respondent to finalise.
Right. And in terms of time allocations, what has been agreed between the parties?
It has been agreed to evenly split the time allocations between the parties.
Right. So we're roughly then looking at 20 minutes or so per individual. Is that acceptable?
20 minutes in total for each?
For each individual.
Oh, for each individual.
Yeah. So 420s are 80 and some extra time for rebuttals or whatever else. In that case, may I invite Respondent to address the tribunal on the procedural issue, and as I said, we're not terribly interested, for the moment at least, in the witness statements. If you could focus on the choice of law and Article 96 issues. And to be absolutely clear, if we never get to witness statements, we, the tribunal, are quite relaxed about that.
Okay. Good morning, Honourable Tribunal. Good morning, opposing counsel. May I first introduce to you my colleague, Laurits Schommers. He will argue on the merits of this case today. My name is Annabella Matichak-Kiala, and I will argue on the procedural issues. We are, as we heard, of the University of Munster, and here on behalf of Respondent, Equatoriana Clothing Manufacturing today. The first issue I will address now is the Article 96 CISG Declaration and what effect it has on the parties. Members of the Tribunal, the core principle in arbitration is party autonomy. Therefore, first, I would like to refer you to the parties' choice of law clause in the contract on page 13 of the record. There we have the parties' contract, and in Article 20, the applicable law. There it reads that this contract shall be governed by the CISG without regard to any national reservations. The wording here could not have been any clearer. The parties chose to derogate from Article 96 of the CISG, since this is one of the reservations under Article 92 to 96 of the CISG. Actually, the reason why Article 96 was included, or the reason more of this choice of law clause, is that the parties chose it from Article 35(1)(b) of the SIAC rules. It is a model clause that they chose. And this model clause was drafted since China had an Article 96 CISG declaration, and the drafters wanted to have a way to disregard this Article 96 CISG declaration. The parties in this arbitration, for this purpose, chose this model clause because they wanted to disregard Article 96 of the CISG, the Declaration of Mediterraneo, which is the seat of claimant in this arbitration. Therefore, the parties did not choose the CISG as a body of law, but a set of rules, and due to their party autonomy, can choose how they want to apply those rules. The reason why parties have such an Article 96 CISG declaration in general is because they want to have protection. They want to protect themselves from hasty decisions. However, when the parties met in Equatoriana to sign the contract, they agreed in writing to forego this protection. This means this was not a hasty decision, but a decision on purpose. However, even if the tribunal should not feel comfortable with this and would like to take Article 12 of the CISG into account, and with this Article 96, I would like...
I guess let me just stop you for a minute. Looking at Article 12, how do you read from that it becomes an agreement by the parties to waive the requirement that there be a writing? I mean, all this says, as I read it, is that it says that it allows a contract for sale or modification or termination to be made in any form other does not apply. So the point there is that it doesn't apply. It doesn't tell you what does apply, does it?
No, it doesn't, exactly. Actually, if the tribunal wants to include Article 12 of the CISG into the party, include it to say it's binding, and with this include Article 96 of the CISG, this, just as you said, does not impose any form requirement on the parties. That's what Article 12 of the CISG actually states. This means, in case we include this provision, this case of a form requirement, which we would need then, is not governed by the CISG. And to fill this gap, we need to have a look again at the parties' choice of law clause. There it is stipulated that supplemented for matters which are not governed by the CISG, we take the UNIDROIT principles of international commercial contracts into account, the PICC. If I may refer you there to Article 1.2 of the PICC. You will find it on page 73 of the booklet. I will just read out to you the pertinent parts of this provision. And there it states that nothing in these principles requires a contract to be made in a particular form. This means in case the tribunal wants to include Article 12, sees it as binding, and with this includes Article 96 of the CISG, we do then still not have a writing requirement, but freedom of form.
Counsel, no doubt your opponent's going to raise this, but I'll raise it now. There is an argument that Articles 12 and 96 impose mandatory requirements from which parties cannot derogate. Could you address us on the party autonomy issue in that regard, please?
Well, this means we have an arbitration here. And since we have party autonomy, the parties are free to derogate from rules and choose just parts of the CISG as set of rules. Therefore, the parties are not bound by Article 12, since they did not want to have Article 96 of the CISG included.
Is it your argument that because this is an arbitration, the parties can do that, and that were this a state court, they could not?
Exactly, since we are in arbitration here, and their party autonomy supersedes normal rules. However, if the tribunal would not want to follow the party's choice of law clause, this would still lead us to the freedom of form. As we can deduce from page 57 of the record.
Let me just stop you for a minute. You know, if tribunals start to take too much liberty with what states would consider to be mandatory law, don't they run the risk of courts increasingly being unwilling to enforce awards because they're kind of running amok and not following what the courts view as mandatory law? Isn't there a danger there to the arbitration process if the arbitrators do that too much?
There would be a danger if the tribunal would derogate from public policy rules, from international public policy. However, what we have here in Articles 12 and 96 at most can be a writing requirement.
How do we decide how important a public policy is? How do we weigh that? What guidelines do we look to as to whether we should or shouldn't give deference to a particular public policy of any state?
Well, first of all, when looking at public policy, we need to look at international practice, what other countries do, and of course on ethical and moral standards. What we have here still is only a writing requirement, which is a formal thing, but not anything that can be seen as international public policy in this case.
But it seems to me, Councillor, that we maybe, perhaps I misread the tone of your voice, but it's only about written documents and things, therefore it's not very important at one end, and at the other, the question of ethics or corruption, and it's a big picture public policy, somewhere between something minor about whether it's a written document or not and these other ones, somewhere there has to be a crossover point. Where do we find that?
Well, the crossover point where we see if something is a public policy or not is actually, it looks to the mandatoriness of this rule in a certain situation. The situation we have here at hand talks about a contract amendment, an oral contract amendment, and about the reasonableness of assuming that there was an amendment. Therefore, the form requirement here cannot take on such a high value as to arise to a public policy rule. However, even if the tribunal would consider those rules to be included, and if the tribunal would want to deviate from the party's choice of law clause, it would then need to apply the other national law or the conflict of law rules of the seat of arbitration in our case. The seat of arbitration here is Danubia. I would like to refer the tribunal.
So you're assuming that the choice of law is a procedural point, and therefore we have to look to the law of Danubia for our conflict analysis?
Well, right now we are still at a procedural point, since we are not talking directly about the oral contract amendment yet, but about what the tribunal is bound by and what is mandatory for the tribunal. Therefore,
Let me stop you for a minute. You know, one of the difficult issues for arbitrators often is whether something is substantive or procedural, and what law we should be looking to make a decision. How do we decide which it is?
Which law it is?
Whether it's a substantive point or a procedural point, often a murky issue. How do we decide?
Well, we would get to a substantive point if we would already talk about the parties' contract in particular, take the statements of Mr. Long and Mr. Short, look at them already, and then decide on all the points of the case and the parties and the circumstances how the tribunal should decide, then we would be at a substantive issue already. What we do now is just talk about general things and about rules of law in general, not only for this case, but also applicable to other cases. Therefore, if the tribunal would still not want to apply the party's choice of law clause, as I said, it would have to look at the otherwise applicable national conflict rules. I would like to refer the tribunal to page 56 of the record, and their question 33. There it is stipulated that the conflict of law rules applicable in those countries, so Equatoriana, Danubia, Mediterraneo, and Oceania, all allow for party autonomy, which would actually first refer us to the party's choice of law clause. In the absence of an agreement, the law applies with which the contract in question has the closest connection. In determining the closest connection, different factors play a role, including the place of conclusion of the contract and the place where the party making the characteristic performance has its place of business. In the record, we find that Claimant CEO came to Equatoriana to sign the contract. So this is also the first part of the test of the closest connection. So here we already come to Equatoriana. The party making the characteristic performance is Respondent, and Respondent is also seated in Equatoriana.
Counsel, I struggle a little with the idea of the place of signature being relevant, and let me explain why and invite you to respond. It is standard practice in the UK oil industry to sign documents to avoid paying stamp duty. So I've spent a lot of my career flying to Amsterdam, signing documents in Starbucks and getting on the next plane home. Is there a close connection between those transactions and Amsterdam?
Well, there is a closer connection in many different points. First of all, since the record already provides for those points, we should take them into account. However, also the parties agreed on Respondent shipping those goods just to the port in Equatoriana, but not to bring it to Respondent's destination, to Claimant's destination, I'm sorry. So this is also a factor we should take into account. And the most important factor actually still is that the party making the characteristic performance, which is Respondent, is seated in Equatoriana. This gives us the highest weight on Equatoriana. Equatoriana does not have a writing requirement. For this reason, freedom of form still applies in this case. If the tribunal would like me to do so, I would now like to address still the issue of the written witness statement of Mr. Short.
Can I stop you there? The tribunal prefer to hear from the claimant on the choice of law and related issues, and then we'll come back to a witness statement if you wish to address it.
Okay, thank you.
Mr. Stavridis, I invite you to respond on the issues which your opposing counsel has addressed.
Thank you, Presiding Arbitrator. Members of the tribunal, it's quite ironic that Respondent's entire argument is based around the concept of party autonomy. And at numerous times, they also mention, in contradiction to that point, terms such as using Article 96 to prevent hasty decisions and, if you will, restricting that concept as a result. It's quite clear that Respondent's argument is in conflict with its own logic. And to address the issues that Respondent has brought up, I'm just going to go through all the different points that Respondent has brought up and address them so as that we can open them up individually. On the point of party autonomy, as I've said, so far we don't understand what exactly is referred to as party autonomy, but it is important to point out that Claimant has absolutely no issue or problem with party autonomy. Party autonomy is a respected principle in arbitration. However, in these proceedings, party autonomy is not the issue here. What the issue is here is what party autonomy has done to, or chosen in this instance, and thus what's the effect of party autonomy. That is the distinguishing difference here. Because when we look at what's happened in this case, we actually find that party autonomy has been used to select, through Clause 20 of the contract, the CISG at Clause 20, which states that, as my opposing counsel has already mentioned, that this contract shall be governed by the CISG without regard to any national reservation. Now, even having selected that clause through party autonomy, the reference to any national reservation, having chosen the CISG, can only extend to Articles 92 to 95, and not 96. Now, that does not mean that party autonomy is somehow affected or altered. It simply means that by choosing this piece of law, the parties get what they've chosen. Now, there's a formula within the CISG, and this essentially is how it works. By choosing the CISG, the parties are, of course, bound to Article 12. Article 12, of course, states quite clearly that at the very bottom of its clause, that the parties may not derogate from or vary the effect of this article. How much more clearer could that be? It's quite clear, and it's quite clear when the parties comply to that piece of law that they cannot derogate from it. And we know from Article 12 as well that if a contracting state or a business has this, if a business has this place of business in a contracting state, in which an Article 96 reservation is made, it is thus mandatory for the writing requirement in this instance to apply. And the effect
does it make any difference that they also have adopted the SEAC rules? And does the fact that the SEAC rules have a specific choice of law provision relevant to the very point you're arguing make those rules rise to the level of being a choice of law with respect to that particular aspect as opposed to just a procedural rules?
Thank you, Madam Arbitrator. The respondent, of course, brought up the issue with China and how the SEAC rules are in some way drafted, or the clause in this instance is somehow a reflection of what China's decisions were in the past. But even if China had used this clause, if you will, to opt out of a writing requirement, that is one instance in one case in which that is used, and that does not affect the capability of the